Well, we hit the 8 o'clock hour, so it's time to get our program running. Good morning, everyone. I'm John Casper with the Oshkosh Chamber, and welcome again to our monthly human resource series that the good folks at Von Briesen and Roper do for us every month. So we've been doing this. I don't know how long we've been doing this, Jim. Several years, I think. Always good programming, good discussion, timely topics, and talking about the right things with the right people. So today we have briefing is on 2021 wage and hourly updates, including unique applications in the COVID-19 environment. Excuse me. We are recording this, so you can go back later when it's online on our website. And we'll push it out to others. One thing we're going to do a little differently is, we are encouraging certainly, questions, comments, that sort of thing. So, feel free to use the tabs on the bottom of the screen. However, we're gonna let you all come in live too. So I will queue you all up to join in on the discussion. So if you do have a comment or have a question, you'll still have to unmute yourself on your end, but we'll be able to allow that to happen. So with that, I am going to turn it over to Jim Macy. Jim, take her away.
Well, thanks, John, and it's a pleasure to be here again this morning. Joined with me is one of my colleagues again, John Iden. I know all of you know John, as he's helped present and put these programs together over the years. Again, always a pleasure. And also, in terms of topics, the topic today is an annual one that we do, but it's also one that we'd had a number of questions from different people about, as to could we again revisit a little bit of what's going on with the wage and hour stuff? What are we seeing in the COVID environment? What are we seeing legislatively that might be coming as far as that goes? That's not to say that we'll do a big legislative update. Quite frankly, we're planning that for next month, kind of waiting a little bit to see what develops well, it's definitely developing, no question about that, on both the federal level and the state level, but we'd like to see it a little further down the road before we start reporting out on it and then what the impacts that it's going to have on the business. But there isn't any question that quietly and behind the scenes, the wage and hour stuff is coming front and center. And as we see the different administrations come and go, and for those of you that have been doing a little bit longer, like some of the rest of us have, there isn't any question that, at least as it relates to the employment, the federal employment agencies, what administration is in power does matter. And the impact on your companies can be significant. There isn't any question that the agencies are more aggressive in the time periods when the Democrats are in office. I don't make that as a political statement. I do make that as somebody that's been doing employment law and working with companies for darn near 40 years. So I've certainly seen the cycles coming and going. And I can say without hesitation at all, that occurs. And it's already occurring. So with that warm up, in introduction, John, let me kick it over to you a little bit to pick up on some of those thoughts. And again, as before I do that, as John Casper said, we're open to a dialogue. We're interested in your impacts, things you have questions about, things that you're seeing, and we'll answer everything we possibly can this morning in the short hour that we have. So John, let me turn it over to you.
Yeah, thank you. Good morning, everyone. Just to start out with the basic application of the law we're talking about, the Federal Fair Labor Standards Act, and there's also a Wisconsin companion. They're largely the same. We're not going to get into all the distinctions, but for the purposes of the classification and the overtime and the minimum wage issues that we're going to be talking about, they are virtually identical. So the application of the FLSA It applies to all employees of businesses with annual sales of $500,000 or more and employees engaged in interstate commerce. And regardless of those thresholds, it applies to all hospitals, medical and nursing care, schools, and public agencies. So the application, while that may sound narrow, it applies to employers, again, $500,000 or more, or those engaged in interstate commerce. And the way that the courts have interpreted interstate commerce is very broad. You may think that we're a small employer that's operating only within Wisconsin, but in this day and age, with the internet and sourcing of materials from outside the state, there's really very few employers that aren't engaged in interstate commerce as that term has been defined under the FLSA. So for all intents and purposes, it's safe to assume that it applies to you. I certainly wouldn't operate under the impression that it doesn't unless you've dove deep into that issue and evaluated your practices. Again, anything related to internet sales, sourcing materials from outside the state, taking orders from outside the state, all of those are going to be triggers for the application of the FLSA to your business. The biggest protections and the biggest issues that lead to potential exposure are the minimum wage requirement and then the overtime requirement for non-exempt employees. Those are the two we're going to focus on. There are some other there's some other components of the FLSA, but again, for today's purposes, that's the issue that we're going to be talking about. And to pick up on Jim's comments about the growth in FLSA litigation and where we anticipate seeing it and where we're starting to see it already in the COVID-19 arena, before COVID-19, we were already starting to see a shift from the plaintiffs' bar to more pursuing more wage and hour litigation, as opposed to what I think a lot of people think about when they think about potential employment liability is discrimination and the EEO laws, discrimination on a protected class. Well, through the programming and through HR professionals and consultants, there's a lot of resources about how to properly document hiring decisions, promotion decisions, disciplinary decisions, establishing a legitimate non-discriminatory reason for termination, going through progressive discipline before making a termination decision. Employers, frankly, have gotten really good at justifying their decisions. And in my experience, never are employers blatantly acting on that reason. But it's the absence of paperwork or the inability to clearly show that that isn't the explanation that oftentimes got employers into trouble. And they're getting really good at avoiding that argument. They're getting really good at gathering and compiling the documentation, whether it be performance reviews or other objective criteria to justify their decision. So the plaintiffs' bar has adapted, and certain ones are better than others, or I shouldn't say better, are more focused on wage and hour than others. But I've certainly heard more and more stories of employees who may have called a law firm asking about whether or not they had a case because they were terminated. And the conversation pretty quickly shifts into, well, what was your classification, and how did your employer handle breaks, and what was your employer's punch clock policy, and when you were on break, were you ever interrupted during your break, and did they police off-duty work, and did you have a company issued cell phone, and were you answering emails or responding or engaged in compensable work on the hardware issued by your employer when you're off duty? That's part now of the interview process for most plaintiffs' firms. And the reason is because, as we're going to talk about next, the damages allow for plaintiffs' attorneys to pursue these FLSA claims regardless of the amount of unpaid time at issue, whether it's a handful of unpaid overtime hours or a handful of interrupted breaks. The amount of unpaid wages to the employee may be small, but as we're going to talk about, there's a fee shifting provision that allows for the payment of attorney's fees. So, and that's by design. I mean, the law was designed to allow for employees, even though they had a couple $1,000s at stake, they didn't want the cost of litigation to be a barrier to pursuing their rights and recovering that amount. But with every good intended protection, there is a flip side of that where it can be wielded as a weapon. And we're seeing that balance and that shift back and forth. So as I talked about, the damages starting first with the issue of unpaid wages or unpaid overtime, what really is owed to the employee under the theory of law under the FLSA, you're looking back at a 2-year statute of limitations, but it can be 3 if the employee can prove that the employer willfully violated the statute. Typically, willful violation requires some evidence that the employer knew or should have known that what they were doing was in violation of the FLSA and didn't correct their policies. And that's a fact-specific issue that's often litigated between the parties. But as a starting point, you're looking back 2 years. So if an employee's been misclassified for their entire period of employment, then they've been employed for over 2 years, you're looking back at overtime issues or uncompensated time for, again, a minimum of 2 years. The employee is entitled to double damages if they can prove the employer. Their employer is entitled to double damages unless the employer can prove they acted in good faith and had a reasonable grounds to believe they were complying with the FLSA. So this is kind of a closely related argument to the willful violation component, but the employer can argue double damages is not appropriate in this case because we acted in good faith and we have reasonable ground. Now, the reasonable ground, there must be, in addition to good faith, you can't just say we acted in good faith, there's that reasonable grounds component. So oftentimes the argument is we've implemented a handbook and had it reviewed by counsel and we were operating under the advice of counsel. We hired this punch clock company to set up our punch clock policy and they established the rounding protocol and we had it reviewed by counsel. So typically the evidence of reason to believe you were acting in good faith includes an argument that we operated under the advice or the recommendations of an outside third party with specialized knowledge in this area. Again, if you're completely insulated and creating all your own policies and not having anyone review or monitor, it's harder to prove that you acted in good faith unless, again, you can show you're routinely reading DOL updates. That extra piece of evidence is important to avoid the double damages. And as I said, the big piece, the big incentive for the plaintiff's bar is, if successful, the plaintiff, the employee, is automatically entitled to attorney's fees. So there's no threshold for this award of damages. There's no obligation to show bad faith or there is no willful requirement. Is, if successful, attorney's fees. These cases are oftentimes litigated in federal court. In the FLSA, almost all of them go to federal court. And that is extremely, the procedure is very regimented. It's very time consuming. There's a lot of formalities that must be followed. The filing fees are higher than state court. Everything about federal litigation is a little more complicated, a little more sophisticated. And as a result, there's a strong argument that the fees that are charged for that work are a little higher. And courts uphold generally on higher hourly rates in federal litigation as opposed to state. And that, again, is the piece of the damages calculation that makes defending these cases so difficult. And that's why programs like this and other audits of your wage and hour issues and avoiding these issues on the front end is so incredibly important, because even if you get to a point where, even if someone files a complaint and you have valid defenses, you can argue you acted in good faith. If you're talking about a misclassification, exempt versus non-exempt, and you want to litigate the duties test, as we're going to talk about, whether the classification is correct is entirely fact specific. Well, litigating a fact specific issue takes time and discovery and depositions, and all of that, all the while you're litigating these fact specific issues, the employee's attorney's fees are racking up, your attorney's fees are racking up, and if unsuccessful in your attempt to, if unsuccessful in your arguments that they were properly classified, an overtime case that was worth a couple $1,000s is now tens of thousands of dollars when you, again, include this component of attorney's fees. So I think two things are important at this point is to, one, recognize the value of preventative action in the FLSA space, and then also to, as we're going to talk about, recognize some of the nuanced issues that are now presenting themselves in the COVID-19 environment. We talked a lot about tracking hours worked, establishing policies for overtime, no overtime without prior approval. And all of those policies are a lot easier to police and enforce when everyone's coming into a central location and everyone is working on the hardware that is in their office or in their cubicle, and you can monitor. It's much easier to monitor. Now, with flexible schedules and remote work, it's much more difficult to capture all compensable work. So this is the graph that shows the most common allegations in wage and hour cases. Minimum wage is fairly self-explanatory. Oftentimes it's some expense reimbursement component or an aspect of the employee's obligation to pay for uniforms or something that drops their hourly wage below the minimum wage. I think most employers are aware of the minimum wage, $7.25 an hour at the federal and state level. With current, Jim talked about the discussions on potential legislation, one of which is an increase to the minimum wage. Donning and doffing is the practice of putting on and taking off protective gear that's essential to the performance of the job. I don't know the origins of those words, but outside of FLSA, I've never heard them. I'm donning my donning my suit to come to work. But if you're having employees who have to put on protective gear or certain protocols related to COVID-19 PPE, if they're doing that prior to punching in, there may be an exposure there that you would have to evaluate for compensable work that's not being captured in the time clock or the hours tracked. Meal and break periods. I think most people are aware that in order for a break to be unpaid, it must be 30 minutes, it must be uninterrupted, and the employee must be completely relieved of their duties. So certain industries are more prone to interrupted breaks. Healthcare is an example where a lot of nursing staff have breaks on, they're supposed to be getting breaks on paper, but emergencies come up and their breaks are interrupted. And if that break is interrupted short of 30 minutes, the whole period must be paid. So accurately capturing and tracking those issues. Misclassification, we're going to talk about that in more detail. Off the clock work is simply employees engaged in compensable work that isn't recorded, either through a time clock or whatever your tracking mechanism is. Overtime is fairly self-explanatory, and a lot of these overlap. An overtime issue is oftentimes tied to a misclassification issue. So they're classified as exempt from overtime, but in reality, based on the tests we're going to talk about, they should have been non-exempt, so now they're entitled to overtime. And then tip pooling is unique to obviously certain industries, and the most common basis for exposure in tip pooling cases is a supervisor or a manager who is taking tips out of the tip pool, and the law is very clear that a tip pool can only be distributed to the employees who've worked in the tipped wage arena. So whenever you have a manager or a supervisor taking money out of that pot, that's a violation of the FLSA.
So let's hold that slide a minute, John, just to talk about this practically for folks. There's kind of interesting in a sense that if you look at the biggest number, it's the overtime kind of pieces. Well, what does that tell us from a litigation standpoint, first of all? And as John described this, and if you talk about law firms and plaintiffs' attorneys looking for work or where the business is kind of heading and why has that become profitable and a target? Well, as John said, there's double damages, there's attorney's fees. Some of this stuff has been around for a while, but again, we're seeing the rise in it now because it's becoming more profitable. So let's take an example. The person that comes in, and what happens so many times in these cases is we get a little lax in our policies and our procedures. And it just sort of happens and everybody's kind of agreeable as to how things are going. There isn't any great intent to hurt anybody or to cheat anybody, but we get lax. Somebody gets disciplined for some unrelated reason and they're upset with us because they got terminated. As John said, now the plaintiff lawyer isn't asking about, well, they're going to ask for the personnel file and did you have a contract and did you have a cause standard and all of that kind of stuff. But they're really going to say, tell me when you came to work. Tell me how you checked in. Tell me how you kept track of your time. Oh, what do you mean that you were allowed or you volunteered you're a good person and you came in a half hour every day early just to sort of get settled and answer the phones and do some other stuff. And your colleagues were coming in a half hour or staying an extra half hour too, and were they hourly or exempt? Well, we just took one person, a half hour a day, multiply that over 2 years or 3 years, then audit that through your workforce. We took a case that might have been a couple hours of overtime, and now we've got huge liability if we're auditing, and they can, the whole workforce as to what our practice was. And that is certainly not beneath the federal agency to bring in their people to audit the whole piece when it looks like we got a bigger problem. In other words, the plaintiff's lawyers are interested in a case, but if there's multiple people involved, it's just multiplied significantly. If it's even bigger, the feds are going to help them with that case. Going back to the days when I worked for the Department of Labor, and this is a long time ago, but it was in the solicitor's office in Chicago. And they would analyze cases based on how much money it could mean to the federal government. There is and was then, and there clearly is much bigger now, a huge fund of money that they'll collect against us, even if the employees don't want it, even if the employees don't take the money. Because again, somebody's ticked, they file a claim, everybody's pulled into it and audited, and half the workforce or more may say, I don't want that. I'm not fighting over that. We still lose. We still write a check, even though it may not go to those folks. The message is we really got to step back and take a look at how we're implementing our policies and how we're keeping track of that time, and have really do it now. Audit your processes now over how you're dealing with your wage and hour stuff on each of these categories. So let's take that a little bit further too. The minimum wage is 10% of the cases because most people simply just pay the minimum wage. It's stayed pretty constant for years and years and years. And where we see a minimum case, wage case isn't because they aren't paying the minimum wage. It's because we made other deductions from pay that mathematically brings the hourly rate under the minimum wage. So if you start deducting for uniforms or equipment or other things that you legitimately can, okay, that can impact the minimum wage. And you may not even realize that all of a sudden we bump down under the minimum wage. Generally doesn't happen that much on the lower wage piece of it, but what's going to be the impact when and if this bumps to $15? And this doubles, and that's clearly in the federal legislation coming through now. And now there's 2 Republican senators that are introducing the same kind of concept under some different ways, but it seems to be gaining momentum. It's been talked about forever. I think we got to look at the impact of that. And if that goes up, it's not going to be just, can we afford that $15? It's going to be, are we doing any other deductions that are going to impact that? And it's going to have a bigger impact than going so low as to the $7 or the $7.50. That's different than all the other little exceptions, not so little, but the little exceptions when we can do less than the $7.50. For example, Margaret, I see you're online here this morning, and this is a concern within our agency and working with you guys and being on the board over there. For groups that get a break based on the nature of the industry, that we might be able to have less than the minimum wage. The current federal legislation is to take that away from us and say there is no breaks for the sheltered workshop scenario. I don't know where the whole discussion is going to go to the tip pooling concepts and the other aspects, but there's clearly a focus to start whittling away at some of this, which is going to impact all these other type of things that we're talking about here this morning.
So Jim, a question came in. What is the recommendation, or how does an employer deal with an employee who you have the policy, record all hours worked, you're going to sign off on your time card that it's accurate, you have your policies in place, but someone is violating those policies? What is the employer's recommended reaction or response?
A great question. Isn't this bizarre? You got somebody that's really dedicated, is a go-getter, wants to work above and beyond. And you got to say, stop being so dedicated. Stop working so hard. And believe it or not, we get to the point that we got to show that we warned them, and we even disciplined, for God's sakes, if people continue to violate your policies or work when they're not supposed to. And we've had to do that and have those kind of cases. As bizarre as that is, that's what's expected, and that's how we got to defend those cases. Now, if we're real clear about that, and somebody continues to work, and they've even been reprimanded for not following the policies and not getting permission to work overtime, it doesn't mean that you got to continue to pay them because they did that. And they may not get paid because they violated the policy, but you got to be careful with that because it's clearly a catch-22. The government will say, if you warned them, they clearly violated, you're disciplining, you might not have to pay, but you're going to invite a case. And we're going to fight about the facts scenario about how well did you do it in your policy and enforcing your policy and making clear they shouldn't work. And their side of the story, of course, is going to be different. So it definitely is having good policies, monitoring those, communicating those, and following up with people that aren't following the policy. They don't get to donate time or volunteer for us to do the same kind of work that they do for us. It's a nice thought, but no good deed goes unpunished. John, any other thoughts?
Yeah, the other piece of the off the clock litigation is a lot of times an employer will say, well, I didn't even know they were doing this off the clock. She has the keys, she opens up the office. I don't know what time she gets there, and I don't know what she's doing after she leaves. The threshold or the case law says that the employer's liable if they knew or should have known that the employee was engaged in off the clock work. So if you can truly argue that you had no idea and it's against your policy and that you, if known, you would have disciplined, then you have a defense. But what is often litigated is, did you have reason to know? I mean, now with everyone utilizing email and the electronic nature of the workplace, there's evidence, there's almost always some evidence that someone's engaged when they're engaged in work. And if this employee's coming in and sending emails prior to their start time, it's going to be hard to argue that you didn't know or should have known when this employee was engaged in compensable work. So that's again another fact-specific piece, and all of these fact-specific issues are really challenging to litigate from the standpoint of the fee shifting provision. I mean, you go deep in the weeds on when was the first time that your support staff individual sent an email over the last 2 years. We're going to spend the time and resources to gather all that data, pay counsel to review it, then we're going to turn it over to the employee to review. We're talking about a lot of time and a lot of exposure, where at the end of the day, it might be that she only sent emails before her start time a handful of days over the course of the last 2 years. But again, the compounding impact of the double damages and attorney's fees makes it paramount that these issues are policed and audited ahead of time.
So let's complicate it because, it's the way the world is. I sit here today scared to death, looking back 9 months of all the work at home stuff going on. And you brought this up in a question, a couple of you right now, in terms of procedures and policies for tracking stuff at home and monitoring that and how we deal with it. I got to tell you, it scares the heck out of me in the absence of a work at home policy, in the absence of good time records. The way time records work, for those of you that don't know, is the burden's on us as the employer. And if we don't have good records, the employee's records win. So the employee that was donating time or doing all this other stuff and says, oh, by the way, here's my records, and we don't have any, we lose. That's just clearly the way the case law is on that kind of stuff. So here's a tip for your supervisors. If you're getting work at home time slips, that's 8 hours, 8 hours, 8 hours, look out. Okay. You and a supervisor that's just signing off on it because that's what we do. We got a problem. All right. They better be monitoring those a lot closer, particularly at the work at home scenario, because I don't think it's just 8 hours. And I mean, I don't know, but are you doing a time breakout? Is there a time period that's showing when their breaks might have been for lunch? Is there a time period where they're working earlier in the day and not the traditional, 8 to 5 kind of scenario? When they're in the office, we can kind of tell. And if somebody's in early and somebody's working late and the supervisor's there and condones it, we lose. Now put that at home when we don't have people that we're seeing every day and the other aspects of it. You gotta have a policy as to how they're dealing with work at home, how they're keeping track of that time, and you gotta have your supervisors really, really working with people to make sure those are appropriate and right. Why? As John said, we're gonna get out of this and we're gonna look back 2 to 3 years back through this time period. And if we're putting it together then, when somebody gets terminated and they're upset, we can have a problem. Let me add another piece to that. I had a deal with the company that I could work comp time, whatever that is in the private sector. And we had some arrangement, a really flexible schedule. And they said, you just keep track of your time and we'll work that out later. And the company says, I have no idea what you're talking about. We don't have a policy of that. Look out for different scenarios. Now, if they totally make it up and you don't have a policy and the other stuff, great. But if there are these deals going on that let's do a little bank of time and we'll work it out later and we'll flex your time doing this, none of us are so naive as to think there are all kinds of flex deals going on over this work at home COVID time period. We're sitting on a powder keg with this scenario to answer that kind of question. John, other thoughts on that? It scares
No, I think that's absolutely right. I mean, I have the same concerns about this time period and back to Jim's point is that these cases almost never arise out of someone who's trying to short their employees for hours that they work. It's the employer trying to accommodate and be flexible and give employees some leeway, and the employees want it. However it's operating in practice, the employees want it, the employers are fine with it, and it then all comes to a head when one disgruntled employee who thinks they got a raw deal brings the plaintiff's attorney or the DOL into the arena and audits the whole practice. And I know right now, all of the employers that I'm working with are doing the best that they can to accommodate employees while at the same time trying to run their business. And in a lot of situations that involves providing a flexible schedule and trying to allow people to work from home when their positions allow for it. But as Jim said, and then the lax enforcement or not adapting new policies for this new work environment over the course of the last year, and at least for the foreseeable future in 2021, is certainly creating an arena where I think we're going to see some very active litigation in the next 2 years. So we kind of went all over the outline, but the one piece that I also wanted to talk about in a little more detail is the misclassification as exempt. And the classification issue is, we've done it before. It can be an hour-long program in its own right as to all of the different exemptions and a detailed discussion of what the duties test is for each one of those exemptions. And we're not going to do that here today, but I do want to just briefly kind of talk about and at least give those of you who may not have a general understanding of the exemptions, that information, and then hopefully an issue spotting level of understanding where you can follow up and perform an audit. And Jim can talk about what what that exemption audit and review looks like. But just briefly, the list of white collar, I've listed here the 5 most common white collar exemptions that are really utilized in the workplace. There are a few others related to farming and some other industries, but the 5 most common, the first being executive, and that's going to be your supervisors and your managers. And clearly the C-suite and the top level executives, it's a fairly straightforward analysis. Where we see litigation related to this exemption are the shift supervisors or the line supervisors, those employees who have managerial responsibility, but also engage in non-exempt manual labor or like I said, shift work. So the duties test or the requirement is that the executives spend their primary duty be managing at least 2 or more employees. The administrative exemption, those are your office personnel who are leading a department. Think of your HR managers, not administrative assistants, but again, those who are exercising independent discretion and control. And really that's the piece that is consistent in both the executive and the administrative exemption, is whether they have independent discretion and can exercise judgment in their duties. So if someone is simply executing directives from their own supervisor, they're less likely to be exempt under the duties test. Your learned professional exemption, those are your engineers, your doctors, your lawyers. Think of as a general rule, kind of graduate level professionals. It's a little broader than that, but that's the shorthand for the professional exemption. Outside sales employees are those who are spending the majority of their time selling outside of the central location of the employer. And then your computer related occupations are your IT professionals. So for each one of those exemptions, there's a 3-part analysis that there are 3 major components that must be satisfied in order to meet the exemption. They must be paid on a salary basis. They must have a salary level that is at least $684 a week. That's the new threshold that was passed in 2020. And they must satisfy this duties test. So really the duties test, when I was going through each of the 5, is where we see oftentimes we see the allegations of misclassification, and the duties test is really where the litigation is conducted. And it's important to note that I think there's a misconception that, well, the employee's contract says that he's an exempt fill in the blank. And the employee understood that he was a salary exempt employee, and we both agreed he was salary exempt. And unfortunately, the meeting of the minds and what is written on the contract and even what is written in the job description, while all relevant to the case and to the defense, what is really going to be examined and where the case really turns is what that individual is actually doing on a day-to-day basis, and whether their duties as actually performed, not agreed upon, not written in the contract, what the duties they're performing qualify as exempt. And again, that's the fact-specific issue that is most often contested, and that's what often leads to the misclassification claims.
So the huge impact of this, of course, is if somebody's exempt, we're not going to have an overtime issue, okay? Those of us that fall into these as professionals, we can work 60 hours a week. We're not paid hourly, and there isn't going to be the overtime issue. If we get it wrong and we do a 2 to 3 year audit, we're going to look at all of that time, and all of a sudden we've got a huge problem. One of the questions asks a little bit about, how does the overtime fold in? Steve, I may ask you to just unmute a little bit and come into the discussion a little bit with it in the question. But a lot of it has to go, of course, to whether or not it's an exempt position or not, and then we don't have the overtime. I want to mention the exception under the computer-related occupations. That's the one area that doesn't necessarily require that next slide, John, which is the salary piece of things, because we can do an hourly rate for some of those positions and still make that exemption. common scenario that we would hear is I put the administrative assistant on salary, therefore she's exempt. Major problem. Okay? Because putting somebody on salary is only one of the three requirements. Okay, that doesn't do it. We still have to pay the salary level, but where it falls down most of the time is not meeting the duties aspect required for that position to be exempt. You may pay a salary basis, you may pay plenty of money for it, but if they don't pass the duties test, meeting those requirements to meet that exemption, we lose and we have a really high liability and we have overtime situations. If I have certain project managers, or I go into the question that was presented a little bit, I have to analyze whether or not I've got an exemption or not that might apply to that quote project manager. And the project manager title itself can be a whole variety of things. It could be a technical position, it could be a professional position, it could be a lot of things that may or may not meet the exemption. For another program as to whether overtime, there are different formulas that can apply for non-exempt positions in unique scenarios on projects, on some other things that may come into play. That's too much for this program today as to whether or not I'm doing a fluctuating work schedule or some of the other aspects of things. I'm just saying there are some nuances for some of those unique positions and unique hour scenarios. And we would have to work on that more specifically and more directly. Also, with a question with some of this, as it comes into hours, John, just as we go back to it, the question was the word de minimis. The word de minimis is definitely a term of art under wage and hour law, meaning if the amount of time is so small or insignificant, it may not count as hours worked. Be careful. De minimis really means a really little insignificant amount of time. Where do I see it the most come up? I see it the most come up in the phone calls people take off hours. I answered a call, it was de minimis. I answered a call for a second just to say, yeah, I'm no longer at the office. That's de minimis. I answered a call for 3 minutes and 36 seconds. And they asked me a very technical question about a project at work, and I answered it. Maybe I'm not so de minimis anymore as I start to get down the road and what was talked about and how much time was involved. John, other thoughts on de minimis or some of the other aspects of that?
No, I think that's a good summary. It's always in play as when we get to, especially when you're talking about, you said off-duty work and oftentimes with rounding policies, but it's a defense. It's rarely an absolute defense. And I generally don't want to hang my hat on none of this matters, because those, as you said, with the 2-year look back, and especially when you start to talk about policies such as a rounding policy that is happening across an entire workforce, that time adds up quickly, and the de minimis argument as a result goes away.
Let's talk a minute about, before we get even to the COVID stuff though, is again, we talked about take a minute and look back at how your processes and procedure are working. And a lot of people did a really good job a couple of years ago when we were looking at this changing the exemptions, and then some case law happened. The Trump administration did change it and up the amounts a little bit, but we think we're going to see that again, where the amount goes up. There's definitely a push in some of the legislation coming that talks about a little bit of the duties test stuff, but it also it's going to make it tougher for people to make some of these exemptions. They want more people covered under the wage and the overtime pieces and less people exempt by policy. I'm not arguing who's right on the policy. I'm just saying where this legislation may be heading. The long and the short of it is audit these positions to make sure you can show a paper trail as to why you got to where you are. Back to John's comment about a good faith analysis as to why somebody's exempt or not. Well, what does that mean to say audit this? There are forms and analysis that gets done in job descriptions and meeting with the employees and matching up those job descriptions to make sure those are the actual duties being done, and then comparing them to the duties tests as far as that goes. It's also a project we get involved in. If you have one that's in the middle, right on the line, and you're not sure, another protection for you is we consulted counsel. We got an opinion from counsel that says yay or nay based on the job descriptions, the actual duties, and a comparison of it. And we write a letter that says what the analysis is as far as that goes. Whether we do it, whether you do it, whatever, your timing is good. Again, even though a lot of people went through this a couple of years ago, be set with that now, because you don't want to be caught up in it later, and there are going to be changes coming for what it's worth. Heads up.
So now that we've kind of laid some general groundwork on FLSA issues and how they're analyzed, talk about some of the COVID specific issues that we're seeing. As we just talked about, the duties test and the exempt analysis is based on how the employee is actually functioning, not what their job title is or not what the job description is. So what happens if, due to COVID and having to reduce staff, now what was someone who was primarily managing is now doing less managing and more non-exempt labor because there's fewer people to manage, and we just no longer need or can afford someone who is just a manager. They have to chip in, or the administrative professional or the outside sales individual who's no longer traveling for outside sales. Does the fact that they're no longer doing exempt work due to COVID impact their exempt status? And the Department of Labor has issued guidance on this issue, this very specific issue, and has said that employees may temporarily perform non-exempt duties that are required by the emergency, being COVID-19, without losing the exemption. So it's important to clarify, and I think it's even better to memorialize in some sort of agreement. It can be as informal as an email, but some type of documentation that shows that the exempt individual's job duties are now changing due to COVID. And that last part's the important part, that due to COVID and our staffing levels or reduction in business, whatever the justification is due to COVID, that this is why you're now going to be engaged in non-exempt work. And the Department of Labor has said that circumstance is not going to impact the employee's exempt status. Now, compare that scenario to the case that I'm litigating right now from before COVID, where the employee was hired to be a project manager. He had indicated he had all this experience and knowledge and skill, and that he was qualified to be a manager, and they put him in the field, and the guy was just awful. No one wanted to work with him. He didn't have any of the skills that he represented, but the employer wanted to give him a chance, keep him employed. So they started using him as simply a laborer. It was kind of a construction industry type application. And he started doing non-exempt labor work because he simply had misrepresented or wasn't qualified to be a project manager. Well, he's now performing non-exempt work, which impacts his ability to claim that he's exempt. And the reason isn't related to COVID. So now that you're in the COVID environment, if the reason the employee is performing non-exempt work is COVID related, that's why I say it's important to memorialize and explain that this is the reason why. And it's not just, this is how we use our employees. They shift back and forth from non-exempt to exempt duties, or there's some other non-COVID related reason. You can help lock in that defense that the DOL is providing you by, like I said, clarifying that the reason why this formerly exempt employee is now doing more non-exempt work is due to COVID.
Let's add the other word, John, that you read into that, and it's temporary. And in your memorializing this is a temporary change. So the good news is the guidance we're getting says we're going to get a break on the duties test to address COVID during the COVID scenario on a temporary basis. So you can adjust, but memorialize it, put something in writing, indicate what that change is going to be, and that it's temporary and it's related to COVID. And then you're going to have to change it later. Don't do that later. If you're catching up later to say, oh, we did that because of COVID, instead of memorializing that now, you're not in as good a position. And you're going to be arguing pretext that we made it up, as opposed to, no, this is what you're not making it up. Of course, you're adjusting because of the COVID stuff, but better to do it now.
And it should go without saying that this analysis wouldn't apply to a new hire. It's after COVID, you're going to be exempt. Right now, you're gonna do non-exempt work due to COVID. This applies to employees pre-COVID who had performed exempt duties and are now doing non-exempt due to COVID. So that's the unique, and as Jim said, temporary application of the rule. So we talked a lot about failure to capture all hours work. So we'll just go through this briefly. But again, as we said, I think the remote work and the flexible schedules that we're seeing due to COVID is an area that is going to need to be evaluated, and where we'll likely see litigation coming out of. I'm just looking to see if there are any comments or points here that we didn't previously address. And again, just stressing the importance of a policy on work schedule. If the employee indicates I have kid responsibilities from 10 to noon, that's when I need to set my kid up on Zoom, and then I can work noon to 1, and then I need to be with my kids 1 to 3, but then I can work 3 to 6, whatever the arrangement is. The Department of Labor has said that for non-exempt employees, you're only required to compensate for hours work. So you can be flexible and you can have this kind of on again, off again work schedule. But the important part is that, one, you memorialize what the schedule is going to be, and then that you track the schedule and hold the employee accountable and make sure that they are in fact working consistent with the schedule. Because when they deviate, that's where the potential exposure is. The last piece I'm going to talk about briefly is the calculation for an overtime rate. So you have an employee who's non-exempt. It's undisputed that they're entitled to overtime, and they occasionally work overtime, and they were hired at $12 an hour. So when they work overtime, we're paying time and a half. That time is going to be compensated at $18 an hour. But we've seen some employers, due to COVID, have added incentive payments or hazard pay, or however they want to classify it, but something to recognize that employees are either coming into the office, or earlier in COVID, we saw it a lot with the grocery industry, that these employees were at work through this entire pandemic, and grocery stores have been open, and those employees have been on the front lines and exposing themselves from the very beginning. And a lot of employers in that industry had some form of temporary incentive payment to kind of recognize this commitment and reward their employees. Frankly, that non-discretionary, by policy, for this month, you're going to get an extra $1 an hour. That is a non-discretionary bonus, and that needs to be taken into account when calculating an employee's overtime. And when you have a policy that says for X period of time, you're going to be paid this heightened rate, it's fairly easy and straightforward. But the tricky non-discretionary bonuses to capture are, everyone's been doing a great job. If we get through the next 2 weeks without any attendance issues or whatever the incentive is, a performance bonus, attendance bonus, the people who are coming in get a bonus, and it's a one-time $100 payment. These, what seem like small gestures, can have and must be, or they're gestures, but they have to be, in addition to that, captured in the hourly rate and used for the calculation of the overtime payment. So you would have to look at the pay period in which that non-discretionary bonus was paid, and calculate not just what their hourly rate was, but add in the bonus, divide by all hours worked, and then do the time and a half calculation. Jim, if you want to, I'll read the question that just came in. If you want to take the first bullet on the additional issues.
And we were working through some of these as we were talking earlier, but what are some of the unique issues we're seeing under wage and hour things and COVID as that goes? You know, one of the questions we're getting now, we've heard a lot of questions about the vaccines and time for that. And part of that's going to have to do with to what degree do you require or mandate vaccines? And to the degree we can still do that, and we make people go do that, and we're not doing it during the work hours, just a heads up, you could have a compensable hour issue. If it's voluntary to get the vaccine, then you probably don't have a compensable hour situation. A little heads up about exempt status, and to the degree that we are reducing hours, laying people off, doing partial shutdowns and other stuff, just a heads up that, as you know, we pay a salary regardless of the hours worked, and it kind of cuts both ways. Don't cut into full work days as far as that goes, and just a heads up not to lose the exempt status when you're reducing hours. Just watch it. That's the heads up with that. In terms of the pay difference for employees that work from home, can you pay somebody less money because they're working at home than not? Well, you know, there are ways that can happen if the work isn't exactly the same, the productivity isn't exactly the same. But a heads up, if you're doing work at home because of an accommodation request versus simply being nice and working through the COVID scenario, those are different scenarios, and we can't reduce pay on accommodations issue. If it's totally different work, that's a different issue, but we're seeing a little bit of those kind of things coming up. John, I don't mean to just run through these. If you got another comment or so, you know.
Yeah, I think that's true. And there are a lot of different reasons why employees would want to work from home. And to the extent that there's any potential argument that puts them in a protected status, whether it's marital status or, I mean, having kids or being pregnant or obviously the disability, if they're requesting to work from home because of something that could arguably tie to protected status, then I think reducing the pay for those individuals could potentially create exposure. I think the safer way to incentivize employees to get back to work would be to pay an increase to those who do come in versus docking the pay for those who don't. But under the FLSA, there's not separating the potential discrimination issues. There's nothing that would prohibit that distinction. The question that came in, I just want to make sure I address it before 9 o'clock here. It's if someone is working from home and then midday they drive to the office to pick something up and drive back and continue working, should they be paid while coming into the office? And the answer is yes. If they're coming in to a location, commuting time has a lot of layers to it, but it is very clear that if someone is during the workday going from location to location or going to run an errand at the direction of the employer, in this case, coming into the office to grab something so they can go back home and work on it, all of those commutes during the workday are compensable.
The other question we had was if it's somebody exempt and they're working less hours in a month, let's say there's 4 days in a month that they're not working, can you reduce the salary without losing the exempt status? And it's possible that you can structure it that way and not lose the status. When you start, if you don't have a policy and a structure for deducting for hours not worked, or you have situations that are less than a day, you got a problem. Same as people taking days off because they're absent because they're sick. Again, they're going to allow us to do some of these deductions and pay for actual time work, but it's got to be by policy and it can't be less than a day. So that's the heads up on those type of scenarios. So, John, I think we kind of covered through those kind of scenarios that we have on the unique things, and I know we covered a number of them as we went through. We do have 9 o'clock. We're respectful of everybody's time. John, any final comments that you'd like to make?
No.
I think we hit the questions. So, John Casper, certainly thanks to the chamber and for the opportunity to give this update. Certainly appreciate all the questions from people as we went through it, and we'll be open later to other questions that people may have.
Great. Well, great discussion as always, Jim and John. We really appreciate you doing this again. As mentioned before, these are the third Thursday of every month. So next time we'll be meeting is on the 18th of March at 8 o'clock. And Jim mentioned before doing a federal and state legislative update. And I know Jim is efforting Ron Johnson and Tammy Baldwin, and along with Glenn Grothman, our congressman, and Assembly Representative Gordon Hintz. They've all been active participants in that. So hoping we get that done. So be looking for that. And again, we thank you all for joining us, and we will see you next time.
Thanks. Bye now.
Thank you.
See you later.